Good morning or good afternoon, wherever you may be. My name is Ken Lee, and I sit on the U.S. Court of Appeals for the Ninth Circuit, and I will be moderating the first showcase panel, The Law, Social Justice, Wokeness, and the Protests. Where do we go from here? This is obviously a very timely topic, and today we are privileged to have a rock star panel. I like to say that this panel is like the law professor version of a Guns N' Roses reunion, except that people here will actually start the show on time. I don't want our panelists to feel too old, but I will say that I actually grew up reading their works. When I was in college and law school in the 90s, I read their articles and their books. They actually weren't assigned in classes, but I heard about them and people told me to read them, so I read them and I learned a lot from them. So I'm honored to moderate this panel. I will introduce our panelists by alphabetical order. First, we have Professor Randy Barnett. He is the Patrick Hotung Professor of Common Law at Georgetown and Director of the Georgetown Center for Constitution. For those libertarians watching out there, Professor Barnett is very well known. I think he's the Axl Rose of the libertarian movement, and I say that in the best way possible. He's been involved in key Commerce Clause cases, ranging from Gonzalez v. Raich, the medical marijuana case, to more recently, NFIB versus Sebelius, the Affordable Care Act case. Next, we have Professor Randall Kennedy. He is the Michael R. Klein Professor of Law at Harvard Law School. He is a prolific author who's written for both scholarly and lay audiences. His book, Race, Crime, and the Law, won the 1998 Robert F. Kennedy Book Award. And I can say it's one of these books that will open your eyes and challenge your assumptions, no matter what your views may be. We also have Professor John McGinnis. He is the George C. Dix Professor in Common Law at Northwestern Law School. He was the Deputy AAG in the Office of Legal Counsel under President Reagan and President Bush 41. Unfortunately, due to an emergency, he couldn't make it today, but fortunate for us, Eugene Meyer is here and he will read Professor McGinnis's remarks. Finally, we have Professor Nadine Strawson. She is the John Marshall Harlan II Professor of Law Emerita at New York Law School. She was previously the president of the ACLU for almost 2 decades, and she is one of the preeminent defenders of free speech and the First Amendment. Her book, Defending Pornography, Free Speech, Sex, and the Fight for Women's Rights, was named as a notable book by the New York Times. So before we've even started the panel, we've already had our share of sex, drugs, and rock and roll. I want to first start off with Professor Randall Kennedy. I'll just pose a question for him to answer and to present, to have his presentation. I think everyone has seen the disturbing video of George Floyd, and that was obviously immediate impetus for the protests and the social movement. My question to you is there something broader that has caused this social movement and the protests? And if so, is the movement an appropriate reaction to that or an excessive reaction?
Judge Lee, thank you very much. And I'd like to thank all who have participated in making this forum available to all of us and issuing the invitation to me. As you indicated, Judge Lee, the immediate cause of the protests of the summer and the ongoing protest was a vivid illustration of police violence against the citizenry. And of course, the episode that was most notorious, the killing of George Floyd, was not exceptional. The fact of the matter is that it was part of an all too familiar pattern of police misconduct, a pattern that has been inadequately addressed by the legal system. You asked me whether there was more to it than that. Yes, indeed, there's more to it than that. Behind this problem of policing is the fact that we still live in a society in which along every index of social life, people of color get the short end of the stick. I don't care if we're talking about educational resources. I don't care if we're talking about access to medicine. I don't care if we're talking about risk of incarceration. I don't care if we're talking about risk of victimization by criminals. We still live in a society that's basically a pigmentocracy. We live in a society in which there is a clear racial hierarchy, and many people of various racial backgrounds are standing up and are saying that they are tired of it and they want that done away with. They want some important reforms. Now, the protests took many forms. There were marches, there were vigils, there were petitions, took many forms, and most of the protest was peaceful. Most of the protest was, as far as I'm concerned, very admirable. Again, you had people from all walks of life in every region of the United States, all ages, all complexions, standing as one, saying that, that's right, Black lives do matter, and they want a polity in which the agents of law and order handle everybody with respect and handle everybody equally. Now, were there problems with some of the protests? Yes. There was some violence. Sometimes there was more than just a little bit of violence. Sometimes there was a lot of violence. Was there some criminality mixed in? Yes, there was. Should this be criticized? Yes, it should be criticized. And there were many people in the protest movement who criticized the arson and the looting because they knew that these things would be used against the protest movement. They did not want to see their protest movement besmirched by people acting in an undisciplined, indeed criminal way. And there were plenty of people who were friends of the protest, and I include myself among that group, friends of the protest who criticized violence, criticized looting, criticized arson. But the dysfunctional aspects of the protests, the degradation of the protest, should not be used to besmirch the protest movement in general, because the protest movement in general seems to me was quite good. Final 2 points. One, or point 4 for me. I'm speaking at a Federalist Society meeting, and I have to say that I was disappointed by the paucity of voices from the conservative side, that the paucity of voices from the conservative side that spoke up against the abuse of the citizenry by police. I was disappointed by the paucity of voices that spoke up against the culture of impunity that so often allows police officers to engage in misconduct of various sorts, including racist misconduct, and not be accountable for it. I was disappointed in the paucity of conservative voices that I heard speaking up against governmental encroachment on freedom of expression and liberty of the press. Finally, in our session here, the question is, where do we go from here? I hope where we go from here is an embrace of certain principles, actually, that the Federalist Society has put forth as part of its mission. So when I speak at Federalist Society meetings at Harvard, the president of the Harvard student group, Federalist Society group, always begins by setting forth principles of the Federalist Society. And one of them, limited government, good. Transparency in government, good. We always have to be attentive to the problem of corruption and abuse by government officials, good. All of those, excellent. There is no place in American life where those ideas can be put to better use than with respect to the administration of criminal justice, particularly the imperative need to put the police under more spotlight, to put the police under more effective regulation. Thank you very much. I look forward to our discussion. Professor Strawson.
Thank you so much, Randy. I echo so much of what you said. And as we have been reminiscing, about 30 years ago, we both shared the podium at another Federalist Society National Lawyers Convention. For me, I've been honored and pleased to speak at so many of these conventions. It's become like a fall tradition. And I, in turn, have a tradition, which is starting by reminding you of your founding principles. To quote from the website, which I revisited this morning, the Federalist Society is founded on the principles, and the very first one that is listed is the state exists to preserve freedom. Sounds like it comes straight from the ACLU playbook. And I have to share the anecdote, as I also regularly do, that in 1995, I was on a panel for a Federalist Society event with one of your founding fathers, Irving Kristol, and he was horrified that that was a founding principle. And I've written down what his words were. He said, "I am shocked to discover that the Federalist Society seems to have said somewhere that the state exists to preserve freedom. The Federalist Society should call a meeting immediately and change that." So that was 1995. And every time I speak at a Federalist Society event, I go to the website to make sure you have not changed that principle. And indeed, I was happy to see that you had not. And you continue to repeat and endorse the principles of freedom, limited government, and robust open discourse. I also saw on your website the About Us section, which I visited this morning, includes a couple dozen testimonials from very ideologically diverse leaders, including people holding very important titles, including United States President, Vice President, Supreme Court Justice, and Attorney General. But I also noticed that of all of these endorsers, there is only one who is quoted not once, but twice. And it happens to be somebody named Nadine Strawson. With all seriousness and sincere great respect, this year above others, I'm especially grateful for the platform of this important convention and this influential organization, because I want to follow in Randy's footsteps in urging you, Federalist Society leaders and members, conservatives and libertarians, to do what I and other liberals have been trying to do, which is to speak out against any attack on individual freedom, the rule of law, other forms of illiberalism, whenever and wherever we see it, especially when it comes from our ideological allies. With that in mind, I'd like to quote an op-ed that came out today, written by Jonathan Zimmerman, who's a professor at University of Pennsylvania. And the headline is, this one appeared in the Dallas Morning News, but I think it's syndicated. The title is "Universities Listen to Biden." And he is quoting from Joe Biden's wonderful speech on Saturday, where he said, let me start earlier. "It is time to put away the harsh rhetoric, lower the temperature, see each other again, listen to each other again. Let this grim era of demonization in America begin to end here and now. And I was so struck by his use of that word demonization, because that is a term that was used both by conservative icon Robbie George and progressive icon Cornel West in the wonderful dialogue they had at your convention right before us. But people like John and I are depending on our conservative and libertarian colleagues in the Federalist Society to do what we have been doing, which is complaining when illiberalism flourishes among our ideological allies. Because John goes on to say, and by the way, he does describe himself consistently as a liberal Democrat. He says most people interpreted that statement by Biden as an attack on Donald Trump. But he says, I heard it differently as a critique of us. Instead of challenging Trump's illiberal spirit, we imitated it. And then he gives some sad examples that are bolstered by consistent public opinion surveys about an air of illiberalism very prevalent on campuses as well as in other sectors of our society, of people feeling afraid to express their views on the most important issues, including the crucial issues that Randy flagged in his remarks. So I'm trying to do it, especially when I find people with whom I share liberal policy goals are using illiberal means to advance those goals. And I wish that the Federalist Society would use your very important voice and influence to do likewise. Because what a difference it would make if every single one of us did that even-handedly and consistently. Now, I want to say, starting with the charge or the topic description that we were given for this panel, I'm going to have a little bit of a bone to pick, because I think it was written in such a way that suggested that the problems are coming only from the left, or predominantly from the left, and from social justice advocates. For example, a key sentence says, for some social justice advocates, the concepts of the rule of law, justice, reason, and discussion are all suspect at best and tools of oppression at worst. Yes, that's true. As John Zimmerman had said, and as I have very often said myself, but we have to recognize that this is a problem that is coming from the conservative, from the right end of the spectrum as well. And it's really important for those of us on either end to be especially brave in criticizing our ideological allies for two reasons. One is because we have more standing to persuade them. And second, because that gives us more credibility when we level the same constructive criticism against our ideological adversaries. So in that spirit, I signed the Harper's letter this summer, which was quite controversial. I also wrote an essay about cancel culture, which is very critical of left-wing cancel culture, which is going to be published by the American Council for Trustees and Alumni. And I want to give a shout out to the person there who did the most work on it, Jonathan Pidlojny, who is a big fan of the Federalist Society and is probably attending this convention. I'd also like to, given the conservative orientation of FedSoc, like to cite a prominent conservative who made this critique about current conservatism, that there is too much illiberalism in it. I'm speaking about New York Times columnist Bret Stephens in a column he wrote on October 30 called Goodbye, Principled Conservatism. He says, what today's debased conservatism now boils down to is anti-liberalism. But anti-liberalism is not conservatism. At its principled best, conservatives support liberal ends, namely the right of the individual to enjoy the maximum degree of freedom compatible with the right of his neighbor to do the same, coming straight out of the FedSoc playbook, as we've seen. And Brett then goes on to say, but principled conservatism holds that these liberal ends are best secured by conservative means, including the habit of a free mind. Anti-liberalism, by contrast, employs illiberal means, the delegitimization of people, laws, and norms that stand for the ideals of an open society. And unfortunately, we've seen too many attacks on those ideals from liberals and conservatives alike. If you want a chapter and verse and specific examples, I commend you to the website of FIRE, the Foundation for Individual Rights in Education, which is very good at keeping track of attacks on all ideas from conservatives and liberals alike. Yes, too many Antifa and other left-wing protesters have engaged in violence, but it's also true that too many police officers and even members of the military have engaged in violence, not only against peaceful protesters, but also against journalists, legal observers, and medics. Yes, campus diversity programs, some campus diversity programs undermine intellectual freedom if they aim to inculcate certain ideas about anti-racism and white privilege. But intellectual freedom is also undermined when officials pressure schools to abandon their chosen curriculum and instead to adopt a so-called patriotic curriculum with other fixed ideas about important issues such as race. Now, surveys indicate that most Americans do support the classic liberal principles of freedom of speech and open discourse. It's just that we have not been speaking up nearly as much as the opponents, the illiberals on either end of the political spectrum. And that is a perfect segue to the question that we were asked to address, which Randy answered as well. What are possible desirable responses to these challenges? And here I'm going to double down again on the opportunity and the responsibility that FedSoc has with such an unparalleled network of representation on campuses all across the country, with lawyers, chapters, thousands of members in government, in civil society, in the legal system. If every single one of you would raise your voices at every opportunity to challenge a departure from your principles, that would make an enormous difference. And let me just underscore from a fairly recent perspective I have on the Federalist Society, something else that you can do on campus that will be wonderful, not only on campus, but beyond. For many decades now, I've been, throughout your existence, I've been speaking at national conventions. But fairly recently, in the last few years, I actually became approved to be on your list of available speakers for the campus lecture circuit. And I've spoken at dozens of campuses at the behest of the Federalist Society in the last few years. In fact, as recently as this morning, I was communicating with Angela Coco, who is a leader of the FedSoc at the University of Michigan Law School, about making a virtual appearance on her campus. And that has really increased my respect for and hope for the positive role that FedSoc can play. Because when you speak on a campus, you are required, or the inviting campus chapter is required to line up at least one other speaker with a different perspective. It is required to seek to co-sponsor the event with other organizations that have different perspectives on the issues. It is required to have a minimum attendance, so it's not just preaching to the choir. And this has worked out beautifully in my experience. And so I would suggest to all the campus leaders, Angela and others who are listening out there, use this opportunity to discuss the kinds of issues that Randy talked about and that I talked about. Line up forums with the Black Law Students Association, with the American Constitution Society, ACLU chapters, students who are interested in criminal law reforms. I think everybody shares the same underlying goals. That's proven by your mission statements, but we deserve to have robust discussions about the appropriate means. So I look forward to continued renewed support in practice, consistently and even-handedly, in support of the positive mission statement of the Federalist Society. And now I hand it off to the John McGinnis, who is not here in person, but whose words will be delivered with passion by Eugene Meyer.
Thank you, Nadine, and thanks, Randy. John, I know very, very much regrets on not being here, and these are his words, not mine. Although I no doubt agree with many of them. But so the rule of law and the American tradition of government depend on the surrounding culture, and that culture is one of capacious liberalism. Liberalism in a philosophical, not a partisan sense. That culture includes a structure built on individual rights rather than group interests, personal responsibility, and freedom of speech. So what are the social movements that threaten this culture today? They go by a variety of names. Wokeism or the successor ideology are two. At a high level of generality, their dogma goes like this. Some group has been systematically oppressed, not only by the government, but society at large. And that oppression is the sole cause of their desperate plight. Anti-racism is an example of the structure of this thinking. Its leading publicist and best-selling author, Ibram X. Kendi, has stated, quote, "Racial discrimination is the sole cause of racial disparities in this country and in the world at large," close quote. All that has gone before is tainted, and society should be completely remade to reflect this essential truth. This kind of ideology poses a serious threat to the rule of law. Begin with the rights-bearing status of the individual. The Declaration of Independence depends on the moral claim that all are created equal and thus individuals are equal before the law. People should not enjoy legal privileges because they are members of a class, as nobility and clergy enjoyed before the rise of liberalism. Moreover, the individual identification under law makes it harder for groups to use politics to oppress other groups. This barrier helps preserve equality of individuals under the law. But a social justice movement that focuses on the group rather than the individual inevitably subordinates individual rights. Exhibit A is the rules on tribunals on sexual assault on campus, where the education department took away core protections from the accused, including access to a neutral tribunal and right to cross-examination. To be clear, the impulse to prevent sexual abuse is wholly laudable. But the dogmatic structure of a movement that wants to vindicate women against patriarchy transform reform into a threat to individual rights. Such movements even create distortions in fact-finding as well as the law. When Michael Brown was killed in Ferguson, the story was told he was a victim of police racism who said, quote, "Hands up, don't shoot," close quote. It took the Obama Justice Department's report to show that this story was untrue, exonerating the office legally. Although he's never been cleared in the eyes of the social justice movement. At my law school, the administration nevertheless continues to display a photograph taken at a school demonstration about this incident of people with their hands in the air. It is imperative for the rule of law that facts not be subordinated to an overarching and totalizing social narrative. Personal responsibility is also bound up with the rule of law. In part, that's because people can take responsibility for themselves only when they can plan, and they can plan only when they know the rules of the game. In part, that's because a government that's large enough to absolve people of individual responsibility is so powerful that the rule of law cannot constrain it. But the claim that some form of systematic oppression is the cause of all disparities between identity groups undermines this premise. The theory of anti-racism articulated by Kendi is an example. It uses racial identity and claims of systematic oppression to rob individuals of agency. It releases individuals from responsibility, both the purported victims and the perpetrators. It is also false. Complex social phenomena in a free society rarely, if ever, have a single cause. Of course, there's nothing wrong with arguing that specific social practices brought into being by the collective decision of some individuals are responsible for bad outcomes. That's a program of potentially useful reform to eliminate such practices. But unless that empirical work is done, this new utopian movement thwarts rather than promotes social reforms. A culture of freedom of speech and tolerance for dissenting views are also necessary to the rule of law and justice, allowing critique of both current law and future reform. But some of the social movements have no interest in free speech because they are dogmatically sure of their own truth. It is hardly an accident that James Damore, an engineer at Google, was fired when he called attention to plausible reasons other than discrimination that account for the lower proportion of women in computer science. If one begins with the incontrovertible truth that systematic discrimination is the cause of all disparities, free exchange is unwelcome because give and take can lead to an appreciation of complexity, not sloganeering. Universities have historically transmitted the culture of capacious liberalism from one generation to the next. Their core form of liberalism is epistemic, an openness to ideas and argument even against the consensus, so that the truth about the world can be discovered. Here too, facts must not be subordinated to an official narrative. Universities have previously faced dangers of epistemic closure because professors are overwhelmingly of one ideology, left liberal. But only recently have university administrations themselves increased that danger by taking institutional positions. For example, many schools like my own law school have now labeled themselves anti-racist. But anti-racism is an encompassing ideology that is not simply a commitment not to discriminate. Indeed, in many versions, it requires discrimination and becomes an Orwellian slogan, another way that truth becomes subordinate to claim of subordination. Other universities require those who want to be hired or promoted to show their commitment to diversity and inclusion in social ideals. When an educational institution adopts an ideology, certainly one as comprehensive as anti-racism, it chills dissenting views and makes the search for truth secondary to making ideas conform to what is thought virtuous. But a virtue signaling university undermines a big part of its core enterprise, making sound inferences about causes and effects of the world. If elites are trained to view society through a dogma rather than openness to sometimes inconsistent facts, they will make America worse, particularly for non-elites, including those who are minorities. Capacious liberalism is the prerequisite for a successful, empirically based social reform, something that is also necessary to the continued flourishing of the rule of law. It's the end of Professor McGinnis's remarks, and I'll now turn it over to Professor Randy Barnett.
Thank you, Gene. It's a pleasure to be here. I wish it would be in person. I miss the Mayflower Hotel, like I'm sure everybody else does. I also miss the presence of John McGinnis on the panel with me. With the current makeup, it looks a little more like an American Constitution Society panel than a Federalist Society panel, but I'll do my best. And I'm very grateful to John for his written remarks, which I think helpfully set up mine. I've been wrestling with what I can accomplish in a 10-minute talk beyond complaining. So I thought I would engage in a bit of self-criticism by offering two observations about the conservative legal movement in which the Federalist Society is a driving force. Doing so is going to require me to make some generalizations that will not apply equally to everyone. My first observation concerns how we can do better responding to claims about social justice, and my second will be how we can do better to responding to claims that are based on what we call wokeness. First, as an antidote to social justice, conservatives, constitutionalists need to spend more energy on the concept of justice. In particular, justice as defined by natural rights, which are affirmed in the Declaration of Independence. It's no accident that my first book, The Structure of Liberty, Justice, and the Rule of Law, was an explanation and defense of the liberal theory of justice. In my experience, because they not unreasonably fear judges making up and enforcing rights, some conservatives tend to poo-poo justice altogether, or at least they give it short shrift. For example, some conservatives like to stress that the Declaration's affirmation that governments derive their just powers from the consent. They like to stress the Declaration's affirmation that governments derive their just powers from the consent of the governed. At the same time, they tend to dismiss the importance of the first part of that sentence, which says to secure these rights, meaning the inalienable natural rights of life, liberty, and the pursuit of happiness, governments are instituted among men. Indeed, some conservatives de-emphasize the role of the Declaration altogether, going out of their way to insist that the Declaration is not law. This was recently done by Justice Barrett in her confirmation hearing. The case of Troxel versus Granville provides another example. In that case, a majority of the court upheld the fundamental right of parents to raise their own children. In his dissenting opinion, Justice Scalia conceded that this right was one to which both the Declaration and the Ninth Amendment refers. He wrote, quote, "In my view, a right of parents to direct the upbringing of their children is among the unalienable rights with which the Declaration of Independence proclaims all men are endowed by their Creator. And in my view, that right is also among the other rights retained by the people, which the Ninth Amendment says the Constitution's enumeration of rights shall not be construed to deny or disparage. The Declaration of Independence, however," he continued, "is not a legal prescription conferring powers upon the courts, and the Constitution's refusal to deny or disparage other rights is far removed from affirming any one of them, and even farther removed from authorizing judges to identify what they might be and to enforce the judges list against laws duly enacted by the people." In contrast, Justice Thomas joined the majority and even argued for strict scrutiny of this right. I suspect the cause of this de-emphasis of justice and natural rights is a preoccupation with a portion of the Federalist Society's mission statement that says, quote, "It is emphatically the province and the duty of the judiciary to say what the law is and not what it should be." Now, this comes at the expense of that part of the mission statement which insists that, quote, "the state exists to preserve freedom." The singular focus on the proper role of judges at the expense of the liberal conception of justice based on natural rights, on the natural rights that define freedom or liberty, is analogous to free market advocates who focus entirely on its efficiency rather than on its justice. Recently, we've witnessed an insurgency in the conservative movement by those who critique the individual natural rights foundation of the American theory of government and advocate a common good conservatism that is highly critical of what it disparagingly calls individualism or liberalism. Now, of course, this criticism does not apply to all conservatives. And a skepticism of judges implementing natural rights, a skepticism which I share, is not logically incompatible with a serious treatment of how the structural constraints of the Constitution work to advance substantive justice. But this tendency to focus on what the law is, rather than what it ought to be, cedes the moral high ground to those who are asserting conceptions of social justice above, say, the original meaning of the text of the Constitution. In my view, social justice is not justice properly conceived. However, without a grasp of natural rights, why they are so imperative, and how the structures provided by the original meaning of the Constitution work to secure these rights, conservatives are unable to clearly explain why it is that social justice conflicts with real justice. Relying solely on a majoritarian conception of popular sovereignty, in which the might of the majority is seen to make right, such a conception has a difficult time responding to objections based on social justice on behalf of minorities. Now, my second observation has to do with wokeness. In my experience in the conservative legal movement, I have found that some conservatives stress the framers and the founding in the 18th century while diminishing the importance of the Republican Party in the 19th century. These Republicans were responsible for ending slavery. They fought tirelessly to protect the freedmen, reconstruct Southern state governments to ensure that they were truly Republican, and ensure an equality of civil rights North and South by enacting formal constitutional amendments and a series of robust civil rights acts. These amendments and laws were gutted, however, by a Supreme Court using a mixture of original intent and living constitutionalist methods, which eventually culminated in Plessy versus Ferguson. The preoccupation of some conservatives with the role of the judiciary has led them to deprecate the privileges or immunities clause of the 14th Amendment. They fail to acknowledge the due process of law requires the substance of laws be within the just powers of legislatures to enact. They also favor extending the state action doctrine beyond the privileges or immunities and due process of law clauses where it is apt, to the Equal Protection Clause, where there is good reason to think it is inapt. Perhaps more importantly, a systemic de-emphasis of the anti-slavery origins of the Republican Party, the civil rights laws and amendments it enacted, and the effort of Republican administrations to enforce these provisions results in a failure to provide a positive contra-narrative to the woke left. In this regard, I've been influenced by my years-long study of anti-slavery constitutionalism, which was deeply informed by natural rights. In the beginning, I did this simply because I found it to be inherently interesting. Now, it's become an imperative. Yet it is a narrative that too few in the conservative legal movement are aware of or appreciate. My con law casebook is organized around these themes and emphasizes how slavery was ended, as well as how equality and civil rights was thwarted by the Supreme Court's passivity in the face of massive democratic resistance. I find that this narrative completely disarms students who come to my class with a woke narrative in mind and expect a certain kind of narrative from me that they do not get. Class discussions, as a result, have an entirely different tenor than they would have in the absence of this narrative being carefully developed during the first third of the course. Now, to conclude, by spending more time on substantive justice at the founding and the narrative of the United States afterwards, conservatives can do much to displace the left from the moral high ground it has successfully claimed. In sum, we have a better case to make than we've been making and a better story to tell than we've been telling. Thanks. Now I turn it over to Judge Lee to moderate our discussion.
Great. Thank you all for the very thought-provoking comments. A little bit we'll open up for audience questions, and for those folks, you can do so by clicking on the raise hand. You'll be in the queue to be able to ask questions to the panelists. But before that, before we open it to the audience, I wanted to give panelists first an opportunity to respond to what other panelists may have said, if they have any additional thoughts or want to respond to any of the points made.
I would love to really thank, I loved all of the comments, but in my little amount of time here, I'd like to single out Randy Barnett. I think your counter narrative is really thrilling and consistent with my idea that there is, we're not enemies left and right. We share a lot, as according to you, even a lot more in common than many on either side understand. And I look forward to reading the more detailed explication that I know you've written. Just one question. I know you had to compress your points. I didn't understand the point about the Equal Protection Clause and state action. Do you mind explicating that a little bit more?
I'd be delighted, although I don't want this panel to get off on a tangent about that topic. But in the book that we have coming out next year, Evan Bernick and I, we try to explain how the duty of protection, and this is something that has also comes through my work on anti-slavery constitutionalism, the duty of protection is a positive duty that government owes its citizens in return for their allegiance. It was an argument that was strongly developed by the anti-slavery movement. Which argued that even slaves had to obey the law, in return for which standard social contract theory said the law owed them a duty of protection. And so even though the state action doctrine properly applies to the Privileged Immunities Clause, which says no state shall make or enforce any law, that's the state action, nor deprive persons of the due process of law, that would also be a state action. The Equal Protection Clause, we believe, imposes an affirmative constitutional duty on state governments to equally protect the rights of each of its citizens, a duty that was one of the principal problems that was facing the Republicans when they were trying to reconstruct the South, when Democrats were denying equal protection. It was one of the principal things that was being done to the freedmen and also to white Republicans in the South. Now, the reason why conservatives and others are very skeptical or doubtful or dubious about this, apart from its original is bona fides, is that they're concerned about judges imposing this duty on local law enforcement and local government officers, which essentially would impose monetary liability to an unlimited degree by means of judicial decrees on local municipalities who have to satisfy these judgments by making payments. I think this, and we say in our book, this is a justified concern. So what we argue instead is that this is not a duty that judges should be enforcing, but it is a duty that was within the power of Congress to enforce using its Section 5 powers under the 14th Amendment by providing alternate remedies that do not impose duties on the states, but provide substitutes for the remedies that states are inadequately providing if a record can be made that states are in fact unequally protecting their citizens. And in this category, we would, for example, have put the Violence Against Women Act, which created a federal cause of action for gender-motivated violence. Regardless of whether you agree with Congress's findings that states were inadequately protecting women, it is on the basis of such findings that Congress created an alternative remedy for women, which was invalidated by the Supreme Court on the one hand because it exceeded Congress's commerce power, which it did, but on the other hand, because it would have exceeded Congress's Section 5 powers under its reading of the scope of the Equal Protection Clause, which in my view, it did not. So if it's objectionable, it would be so on the grounds that Congress had an inadequate record before it in order to justify this, but not on the grounds that doing so in the face of an adequate record was within the Section 5 powers of Congress to enact.
I have a question for both Professor Kennedy and Professor Strawson. Let me start with Nadine. You talked about the importance of the Federalist Society doing debates and with other groups, which we try to do a lot. The increasing problem we've had, and it hasn't reached a critical stage yet, but it's gotten more and more serious, is it is getting increasingly difficult to set up debates, to get other groups to debate, to agree to be part of the debate, and sometimes even get debating opponents. It's a commitment we have had from the beginning and still very strongly have. You may have slightly overstated how much we try to force chapters through debates, but we definitely very, very strongly encourage it, and mostly they try to. But I don't know if you have any thoughts on how to get more of these groups to agree to debate. I think, and I'm going to leave that question for 1 second and ask the question I had of Professor Kennedy, because it's somewhat linked. One of the things that's going on currently, and I'm not saying things aren't going on both ways around, they undoubtedly are, but there is a fair bit of attempt to, quote, cancel, close quote, or whatever term you want to use, those people who've done things that, so either supported Trump or in some way or other done something aligning themselves with Trump. And there have been things written saying somebody who's done that should never, basically, you shouldn't hire the law firm that has represented him. You should pressure the sponsors of the firm not to represent, not to do business with the firm because they represented him. And the two things are linked because both are attempts to counter, to make it so that you do not just you disagree with someone, but you try to go after their jobs, their livelihood, their, and that's certainly has gone on both sides. And clearly, at some stage, society has certain principles where when 99% of the people in society think something is horrendous, people are going to respond negatively to that person. But when you're starting to do that with 25, 30, 35, 40% of the society, that strikes me as dangerous. And I wonder if you have thoughts about what to do about that. So.
I think we are in a very dangerous moment. Let me say first a word about your first question about people not, for instance, organizations not wanting to co-sponsor events with the Federalist Society or people not wanting to come to debates. I think that one of the reasons why some people don't want to show up, don't want to co-sponsor is because they don't want to do anything that's going to further legitimate, further entrench, further empower the Federalist Society. They think, frankly, I thought about that I mean, before I came to this panel. I mean, you know, one of the Federalist Society is powerful, and one of the ways in which it discusses itself or makes itself attractive to many people is to say, yes, we are conservatives, we are libertarians, we're on the right side of, you know, the political spectrum, but we open ourselves up to self-criticism. We have people come to our meetings, look at Nadine Strossen, look at Randy Kennedy, look at other liberals, and think well of us. Now, I think that there are people in my camp. I'm a progressive. You know, my peeps are the people who, you know, are around, let's say, the American Prospect magazine, The Nation magazine, Dissent magazine. Those are my people, ideologically. And some of them would say, listen, you know, Kennedy, the Federalist Society, when all is said and done, they can say nice things, they can, you know, give nice speeches like the ones you've heard today, but when all is said and done, a large number of them are followers of Donald Trump, who has been and is right now a danger to democratic values in the United States of America. And no, we do not want to participate. We do not want to help one whit any organization that is going to line up with Donald Trump. That is what you face. And, you know, the fact of the matter is, it's not as if, when I talk with my friends who say that, it's not as if they are crazy. It's not as if they don't have a point. They do have a point. They do have a point. And that was part of what I was saying. It is really too bad, as far as I'm concerned, that there were substantial parts of the Federalist Society that have kept quiet in the face of an absolute danger to American democracy. We can disagree about various things. We can disagree about affirmative action and all sorts of other things. But we have seen in the past couple of years boundaries crossed that were fundamental. And I think that there's some people who said that people who cross those fundamental boundaries ought, frankly, to be ostracized. And, you know, as you indicated in your remarks, it's not as if all ostracism is bad. Under certain circumstances, there ought to be ostracism. Now, I think we are in such a dangerous moment. For me, it's been a very chastening point, because I must say, given what's happened, I do have a new appreciation for norms of civility, for norms of compromise that I didn't have before. So I am here. I am speaking to the Federalist Society, and I would do it tomorrow as well. And if the people at Harvard ask me to debate somebody, I will do it again. But do understand the thinking of people on the other side.
I would just add to that. It's more than a matter of terminology, but I prefer the term discussion or discourse or dialogue to debate, because I say that as a champion debater from high school. The point of a debate is to win. And I think what you should be fostering, and I know from the form letter that you send to your student chapters, you are encouraging robust discussion through the opening statements that present differing perspectives. But that doesn't have to be a point counterpoint, you know, black, white, binary. It's a recognition that these are complicated issues and there are different perspectives and different evidence and analysis that should be considered. So I think if that is emphasized, that this is to bring people together to further understanding among all of us, and that all of us have our understanding enriched when it is cross-fertilized with a variety of perspectives. That might, perhaps the word debate suggests that, well, the Federalist Society is trying to win this, and we don't want to throw a sacrificial lamb into it. Also, all organizations at every level are composed of individuals, and all of us individuals who care deeply about bringing people together with different perspectives have a responsibility to act as role models, to act as leaders, to set the tone. So, for example, not just the first, I think the second, even in a few months, discourse you had between Robbie George, such a prominent conservative, and Cornel West, such a prominent progressive, unhesitatingly seeking and welcoming this platform and speaking about the positive role that the Federalist Society can play. I would hope, and Randy, I trade on the fact that you speak regularly, Randy Kennedy, but also Randy Barnett, who's part of the libertarian wing, which I think is often ignored or not given as much attention as the conservative wing. And also I see at the level of individual chapters, the individual personal relationship between students who are members and leaders of the Federalist Society and the American Constitution Society. On my own campus and many others, there is a lot of cross membership. Students who are genuinely interested in the full range of programs, the full range of perspectives will join both organizations. They have a great deal of trust and respect for each other. So we have to emphasize that kind of personal conversation. And then I think at the national level as well, at least in my experience, there were always very good, cordial, collegial relationships between the national leadership of ACS and national leadership of FedSoc, even despite disagreement on very important policy issues.
Professor Barnett, do you want to respond?
Yeah, let me respond a little bit to what Randy just said. And Randy and I should just mention, have known each other for a very long time and gotten along very well. I hope this session is not going to be the end of that friendship. But I want to reassure him that we are not unaware of what progressives think about Donald Trump or people who support Donald Trump. We are well aware of what they think. I have a couple of comments to make about that. Number one, none of the issues that we're talking about today began with Donald Trump or began during the last 3 years. They precede that. Donald Trump is not the cause of this. Donald Trump is a symptom of it. Donald Trump is a symptom of people who looked on the stage of the candidates that were on offer for the Republican nomination in 2016, and I was a senior member of a senior advisor to one of Donald Trump's rival candidates, Senator Paul. They looked on that stage and they really they thought only one person, or at least a plurality of Republicans saw one person they thought was capable of standing up to, fighting back, and not be cowed by the type of aggression that we do witness from the left, both verbally and physically. Whether they were right or wrong about that, that's the guy they thought on the stage was just crazy enough to do what he said he would do. And where all the other ones up there were mere politicians who spouted conservative platitudes while doing pretty much nothing and cowing whenever attacked. Whether they were right or wrong about that calculation, I think that's what launched him or put him at the head of the pack, among other things. So that's number one. Number two is that I think there's a certain amount of both sidesism that we've entered into in this discussion. What we are all talking about, I think what this panel is really about, is an attack on liberalism that is happening within academia in particular, and then and that has now permeated the society in general. And Nadine, I know, fully agrees with this. I mean, and her comments are fully in the spirit. But it isn't symmetrical. Of course, you're always going to be able to find an example on the other side of something. But that's not really what's happening here. The shutdown culture, the cancel culture, the intimidation culture, the going after donors culture. This is predominantly coming from one side, aimed at shutting down discourse on the other side. And I know that in the course of characterizing the Federalist Society, Randy referred to it as powerful. It's a private organization. It's influential. It's influential. It's very influential with some people. But whether it's powerful, I don't know if it would be accurate to call it powerful in the relevant sense, because it really has no power other than the voice that it represents. And the fact that it represents a singular location where all the people who are generally shut out of mainstream, very, very influential, and I might even hazard to say powerful institutions like Harvard Law School, that's the Federalist Society is really the only place they have to go, or the principal primary place they have to go. And as a result, they're all in one place and they can speak in a more influential or powerful way, if you will, than they would otherwise have if they were dispersed throughout academia, which they are not allowed to be by the discriminatory hiring that is done by most law schools, including my own, who are liberal enough to hire me, but not that many more than me. And so the final thing I would say, if we move beyond academia and we talk about protests, which is the subject of this panel as well, is that the District of Columbia, where I reside, although I am not residing at the present, I'm actually taking refuge in Central Virginia from the virus, but where I also reside is in the District of Columbia. The District of Columbia was boarded up in anticipation of this election. And I can assure you that it was not boarded up in anticipation of right-wing violence. And one way I can show that is that it really looks like Joe Biden has won the election, or that's the way it's going. And we're not seeing any right-wing violence. Everything seems to be pretty peaceful. It was being boarded up in response to left-wing violence. And I understand Randy, and I really appreciated Randy's earlier comments in which he said that, you know, his colleagues and friends condemned that violence, and I believe him. But nevertheless, despite that condemnation, that is where the threat to civil order is coming from predominantly. Of course, you can always find examples on the other side of a provocateur here or there. But if you want to generalize, as we generalize about police and we generalize about racism, we can generalize about the source of violence that's shutting down discourse, intimidating and destroying private property and destroying the very livelihoods of the people and businesses that serve the minority community in many cities. The last thing I guess I will say is that, you know, it was a huge accomplishment that took place over my lifetime that big box retailer stores were prepared to open up in the inner cities. Used to be that the inner cities were reliant on mom and pop stores and other kinds of bodegas that charged higher prices for a variety of reasons. And Target and Walmart and a bunch of other big box stores, it was a revolution that they were prepared to open up in Washington, D.C. and in other municipalities to provide reasonably priced, high quality services to the minority communities. And all of that is put under threat by the attack on private property that has been justified or at least legitimated by those who support this form of protest or who at least don't adequately condemn it. And in that, I would also include the Democratic nominee or the Democratic candidate for president, who made a perfunctory statement about this when it politically was necessary for him to do so, but otherwise ignored it, along with most of the rest of the media, who attempted to say that the buildings burning behind them were a product of mostly peaceful protests.
Can I respond?
Absolutely.
Number one, to go back to your very first sentence, and it's too bad that we're not face to face. That's right. You and I have been talking for several decades. For the first couple, it was mainly about contracts, but now it's broadened out. You don't have to worry about. I've listened to you. I look forward to reading your work. I look forward to future discussions. There's nothing at all that you've said that would, make me hold you in any less esteem. So that's point number one. Point number two, I agree with you about the, as every speaker has said here, the attack on, just sort of fundamental notions of liberty, fundamental notions of due process, fundamental notions of individualism. I completely agree with you about, for instance, the looting, and frankly, in a certain sort of way, even worse than the looting, because many of the people that are doing the looting are they're criminals. They're pathetic and they're criminals. In a way, even worse has been the defense that has been voiced for the apology for looting, that has been publicized in magazines to which I contribute. Again, this is in my camp, and I find it appalling. Disagree, have disagreed, have renounced, have denounced publicly in writing, in voice. That's point number 2. Number 3, Randy, when you talk about, power, listen, in the last few months, there have been efforts, Nadine Strawson mentioned this, there have been efforts to put the arm on institutions of higher education. Don't teach that, or your funds will be cut off. It seems to me, I read the, I listen to people talking about wokeism, and there is a problem with wokeism. I hear people talk about political correctness. There is a problem with political correctness. And I'm not at all averse to criticizing that. But then when I hear about legislation being proposed, cut off funding if you're going to talk about critical race, theory, I'm waiting for people to say, hey, no, we're not down with that. We don't like critical race theory, but we don't want the government telling people or pushing people or strong arming people, telling them what they can and cannot teach. And I would expect you, and I would expect, Federalist Society people to stand up and be heard on that. Do we disagree on that?
No, we don't. And we also I don't know if we disagree about whether the federal government should be in the business of funding education like that at all, such that once you create the power in the federal government to do that, then the federal government is going to start making choices among what it can fund and what it can't fund. That's possibly one of the problems that gives rise to this opportunity for that kind of curriculum control.
Now, I want to open it up to the audience for the remaining time period. But before we do that, I want to mention the CLE password. It is CIP87, C Cat I Independence P Party 87.
I just want to thank Randy for the first 2 points that he made. We can move on, but I just want to tell him that I heard every word. I really appreciate the fact that he said every word.
And first person we'll call on is Professor Ilya Soman. If you can unmute your line and ask a question to the panel.
Can you hear me?
Yes,
the question was inspired by something that Randy Barnett said, but I'm sure other panelists might have thoughts on it as well. That I agree with, I think, with most of what you said about that it's important to emphasize the 19th century Reconstruction, at least as much in some ways as the founding, and also emphasize the history there and what it was responding to. I wonder if you would extend that point, or perhaps others would, to also acknowledging, I think, more fully than many conservatives and also some of my fellow libertarians are willing to do, that the original founding was in fact very flawed on these issues of race and slavery, that at the very least it tolerated slavery in the states. It had the Fugitive Slave Clause. I know in your work on anti-slavery constitutionalism, you have highlighted people who said, well, maybe the Fugitive Slave Clause doesn't really mean what traditionally people think it means, but it was certainly still there. And there are other examples as well. So that doesn't mean we should necessarily go to the lengths of the 1619 Project and say, well, it was all just really about defending slavery, and that's what the American Revolution was about. But at the same time, it was a bunch of people on the one hand said, we're champions of liberty. On the other hand, they continue, many of them, not all, but many of them continue to keep slaves. and some aspects of the Constitution they created offered protection to that institution of slavery. And it seems like many, not all, but many conservatives and some libertarians as well are, perhaps have not acknowledged that as much as we should.
And not only do I agree with that, I mean, my casebook, which I mentioned in my comment, is organized around that very principle. The reason why there was a need for an anti-slavery constitutionalism to develop in the 19th century is because of some of the mistakes and errors and sins of the 18th century. And so that was implicit in my argument that it should be that the process that led up to the Reconstruction era, and then how the Reconstruction era was undermined, was made necessary by the founding. And my casebook goes into this in great detail, as does the video series that Josh Blackman and I produced as part of our book, 100 Cases Everyone Should Know, an Introduction to Constitutional Law. We have whole videos on slavery. So yes, absolutely, it is a part of the founding. But I just should also point out, anti-slavery was also a part of the founding as well. And even though every state in the Union had slavery at the time in 1776, close to half the states of the Union had either eliminated slavery or are moving towards eliminating slavery by 1787, which is a relatively short period of time. And in fact, a pro-slavery ideology in this country did not develop until after the founding. It was almost immediately after the founding when the economic profits to be made by cotton plantation slavery were greatly enhanced by the invention of the cotton gin, which happened 2 years after the Constitution was enacted, and thereby gave rise to a very, very profitable plantation industry in cotton production that then gave rise to a pro-slavery ideology that didn't really exist at the time the Constitution was written and enacted. All of this is much more interesting and more complicated, but in some respects more favorable than the kinds of stories we get on either side that idealize the founding or that demonize the founding. The reality of the founding is actually a lot more interesting and therefore helps explain what happened after the founding, which is as important, I think, as what happened at the founding.
Next question will be from Sylvia Ross. If you can unmute and ask your question.
Well, thank you very much. Can you hear me?
Yeah.
All of you were wonderful speakers. I appreciate it. A bit fast. I'm a little on the slow edge here, but my question is really for both Professor Randy's, I'll call him that. First one had to do with your point, Professor Barrett, Randy Barrett, Barnett, I'm sorry, that you mentioned the Declaration as law. And I'd like you to maybe just expound on that a little bit and how you see it in relation to being read with the Constitution and the solution to maybe addressing some of these things. And I'd just like to hear Professor Kennedy's comment on what you may have to say.
Great, thanks. No, I didn't claim that the Declaration was law. I claimed that conservatives go out of the way to dismiss the Declaration as not being law, and thereby undermine its significance. In fact, I think and I have a short essay that I delivered at the student symposium at Georgetown a couple of years ago about how the Declaration was the officially adopted American theory of politics. It was the American political theory that was officially adopted unanimously by each of the 13 states. And so that is the political theory of our country. And then after the political theory of our country was officially adopted, there were two cracks at government. The first was the Articles of Confederation, and then the second was the Constitution. So first came our political theory, which is based on natural rights, and then came two forms of government. Whether you think that the Constitution was better than the Articles or not, the Constitution, was arguably an improvement, but one that was highly imperfect for reasons that we just talked about, and that needed to be improved further, and eventually was improved further through the efforts as well as the lives of many, many millions of Americans. And so that's what I meant. I said that the Declaration deserves to be a centerpiece of our discussion over justice, which is what that was that point of my remarks. I was talking about how conservatives need to pay a lot more attention to justice as opposed to the rule of law. Sometimes I would have to admonish my libertarian friends that they have to pay more attention to the rule of law as opposed to justice. But that just goes to show that I'm a contrarian no matter which group I find myself in.
We can get another question. I agree with much of what Randy said.
Could I just make one point? I'm holding up here the Cato Institute edition of the Constitution and the Declaration of Independence. And of course, Cato is on the libertarian wing here, but very involved in the Federalist Society. This edition includes a wonderful introductory essay by Roger Pilon, long the head of the Constitutional Project at Cato and a big activist in the FedSoc, which explains the integral interrelationship between the Declaration and the Constitution. I highly recommend it.
I have my copy here as well, handy. The next question will be from Rashida McMurray Abdullah. If you can unmute and ask your question.
Great, thank you very much. This has been a very interesting panel. I first like to say, Professor Sorensen, I love the fact that you alerted us to the fact that it should be a discourse instead of a debate. But my main question is actually a question for Professor Randy Barrett. You made a comment with respect to that the violence was being and I'm kind of paraphrasing, that the violence was really coming from the liberal wing with respect to the election. But I want to understand is how do you reconcile the fact that certain groups of individuals in this country have had to continually go to the Supreme Court to get the rights that are enacted in the Constitution, to get them enforced? And then how do you reconcile that with the short time of slavery and that thinking about denying people the inalienable rights when we still had Plessy versus Ferguson in 1896, almost 100 years later, where we were really having state-sanctioned violence? And I would say that that was not the liberal wing at that time with that state-sanctioned violence. And then with your response, if Professor Randall Kennedy has anything to add to that comment, I would appreciate it. Thank you very much.
I'm sorry, but I lost internet completely and had to sign back in halfway through your question. So I didn't catch the beginning of your question, which I take it was addressed to me.
It was addressed to you. So the first part of my question, you mentioned a comment about talking about the liberal wing of violence, particularly with the election. You made a comment there was some concern because DC was boarded up. And so it was more so being more concerned that the liberal wing was going to be violent rather than, I guess, the non-liberal wing or the right wing. I always find that those terminologies of label not really helpful for the discourse, but I did say that Professor, so I would appreciate it that she changed the conversation from discourse as opposed to debate, because I do think that's helpful. But really what I really want you to opine on is how do you reconcile this conversation about individuals who have continually had to go to the Supreme Court to enforce their rights in a way of protesting and making sure that their voices were heard, and talking about this kind of liberal right-wing violence when we had such a long history of state-sanctioned violence? And I would say that could not be characterized as liberal wing violence, the state-sanctioned the violence. You had made a point about that it was a relatively short period of time when we had the kind of discourse about anti-slavery, but I would argue that any day in slavery is probably a day too long. But then it was not until 1896 where we had Plessy. So that's 100 years after that discussion with respect to separate but equal. So hopefully maybe that's where you came back in. And then I said it would be great if Professor Kennedy had a rebuttal to that as well. So thank you. Right.
Okay, I got it now. By the way, I really didn't use the word liberal to describe the violence that was being feared in DC or anywhere else. I tend to reserve the word liberal for liberal, and I like the fact that most liberals today call themselves progressives, so I can reserve the term liberal for myself and for Nadine Strawson. So I didn't label it. In fact, I don't believe I labeled it at all. Nevertheless, I would probably say, if I was going to pick a label, I would probably say leftist or something like that, to the left of everybody else. But be that as it may, I really think the more important part of your question has to do with our history that you've just alluded to at the end. And I would say, you know, it's worse I mean, it's even worse than it you say, because Plessy was not the end. Plessy was the middle of 100 years of state-sanctioned segregation, state-sanctioned subjugation of people on the basis of race by another people in large parts of the country, in addition to other practices that were happening in the North. And this is a part of our history. So I think, and again, this is emphasized in my casebook, the Civil War didn't end it may have ended slavery, but it didn't end the problem that slavery was a product of. And it took another 100 years to do that. You know, it has been pointed out by better historians than me, it wasn't really the Supreme Court that ended this discriminatory practice. It was the organized political pressure brought by African Americans themselves, along with other compatriots that they had throughout the 50s and the 60s, which culminated in congressional laws that helped address this practice. The Brown versus Board of Education was well in the rearview mirror when those laws were passed in order to address this. So at any rate, I would just say that a full account of our history demands a recognition of that. But I will also say that it was, in my view, now this is where I expect a lot of constitutional law professors to get off the boat. In my view, it was a failure to adhere to the original meaning of the 14th Amendment, as well as the 13th and 15th Amendments, and a failure of judges to enforce that, or at least to allow Congress to enforce the rights that were protected by those amendments in the form of civil rights acts that were declared unconstitutional in the 1870s, that helped, made possible 100 years of subjugation. And so I believe this is a way of understanding why originalism, which is the view of interpretation that I favor, is a good one. It's an imperative one, because I think our Constitution is now a legitimate constitution, a constitution that on balance is a good constitution, because of not only what happened at the founding, but how the Constitution has been changed by amendments since then.
We have a really remarkable thing going on now, because Randy, you sound like you're an intellectual comrade of the great, as far as I'm concerned, the leading American living historian is the great historian Eric Foner. And Eric Foner's latest book, The Second Founding, is completely consistent with your view. I mean, you know, Eric Foner is saying, you know, everybody's talking about the founding fathers. What about the Republican founding fathers? What about the founding fathers of 1868? And he takes a very originalist view of the 13th, 14th, 15th Amendments, and suggests that if they were interpreted, you know, correctly, that would give a lot of oxygen to a mission that, you know, still needs to be carried out in the country insofar as racial justice, and in fact, you know, other forms of justice. With respect to your other,
can I respond to that?
Yeah, sure.
I'm a big fan of Eric's. I'm a big fan of Eric's. He's been a lecturer. That he was a Salmon Chase lecturer of the Georgetown Center for the Constitution, which I direct. And I'm a big fan of his work. I've been greatly influenced by his work. I don't agree with every claim he makes about the original meaning of these amendments, but on balance, he's a hero, because he, in the 1970s, before anyone, well, not before anyone else, I'm sure there may have been others, but first among all, from the radical left, I should say, fought back against the Dunning School of History, which celebrated the great lost cause of the states' rights movement representing the South, a complete revision of what happened during the Civil War, from which Reconstruction became totally associated with the word carpetbaggers, and which President Grant is disparaged, notwithstanding the fact that he fought so hard for civil rights. It's Eric Foner from the radical left who was the first person to push back against this. And he told me he told us when he came to our conference that he got into this as a result of doing a high school presentation in which he pushed back against the conventional wisdom that he had in his high school in New York. And that's what started him on this quest. So yeah, I'm a big fan of his. He's influenced me. And I recommend people read his work. But of course, he's not alone. I would also recommend people read the work of Sean Wilentz, who's written this book, No Property in Man, which is a reevaluation of anti-slavery sentiment at the Constitutional Convention and the degree to which anti-slavery delegates push back against pro-slavery delegates who tried to insert the concept of property of man in the text of the Constitution and failed to do so. And as a result of their failure, it allowed an anti-slavery constitutionalism to develop consistent with the text of the Constitution afterwards. That was a major accomplishment that they did. And I highly recommend Sean's book, No Property in Man, which the Center for the Constitution has given its 2021, or will be giving its 2021 Cooley Book Prize to honor. And now I interrupted you. We're going to make a second point.
No, let's proceed. Thank you.
We have about 5 more minutes, so maybe we can take one more question. Let's see, Alexander Cohen, if you can unmute and ask your question. Okay. You may have dropped off. So we'll move on to Susan Lehman. If you can unmute.
Hi, can you hear me?
Yes.
Hi. Okay, so it seems to me that the woke culture it's a practice of a sort of a reverse motivation assignment. So take, for example, Breonna Taylor. You know, here's a person who's a Black American and very, very tragically shot to death by somebody who's a white American. And so then it's assumed that there are racial motivations and other things as well. In other cases, I mean, not involving police. So you're assigning motivation and you know, if somebody gets fired from their job, you know, or other consequences for being an active supporter of Donald Trump, well, then you must be at least, you know, a sympathizer. So it takes the individual out of it. So Breonna Taylor is a member of one group. The police officer is a member of another group, ethnic group, racial group. So it seems to negate the concept of the individual altogether. So how do you have individual rights if you negate the concept of the individual altogether? So that's part one. And then the other very simple question is, at what point, especially with people who are not in public life, does it become slander and libel? That's all. And by the way, I think that many of the answers to our problems are not in the state. That's not to say the challenges aren't there, but I think many of them are, the solutions are spiritual and interpersonal. You know, there have been skinheads. I saw one guy, Christian Piccolini or something like that. He was a former skinhead. He changed because he opened a music store and started having interactions with the Black Americans in his neighborhood who were shopping at his store, struck up a conversation with one young man whose grandmother was going through cancer, and Christian had a relative who had died of cancer. So all of a sudden, here are these bridges.
We have only a couple more minutes, so if
okay. Well, that's just, I mean, I went on because you guys hadn't jumped in on my question. So those are my questions. How do you have individual rights when there's not a concept of the individual? And at what point does this become slander and libel?
On the question, on your question of many sources, I would agree with you, Ms. Lehman. Yeah, the fact of the matter is this is a crisis that confronts us on many levels. It's political, it's cultural, it's social, it's spiritual. So yes, there will have to be many sources that are mobilized to lift us, to lift our country to a higher place on the issue of racial motivation. People ought be careful in making allegations of racism. People ought not overgeneralize. That's absolutely true. It's also true, however, that if you talk with Black people and you just in a conversation, you just talk with Black people about especially the police. The fact of the matter is that wherever you are in the United States, you get in a conversation and you are going to hear stories about being harassed, being disrespected, being abused by the police. This is a deep thing. It's not a figment of anybody's imagination. It is for real. It has been studied. One can indeed quantify it. I mean, there's been a lot of study of the sociology of policing. And it's something, again, about which we're going to have to come together. We're going to have to deal with it. And while we're, I know that we're about to get the hook, I want to emphasize again, going back to my first comment, the Federalist Society has principles. I think in many respects, they are good principles. Apply those principles in the administration of criminal justice, and I think that you can do a lot of good. Finally, I just want to say, for me, these last few months have been, they've been a roller coaster, and there's been a lot of darkness in those months. I must say, I do find some solace in this meeting. I have thoroughly enjoyed being a part of it. I wish everyone well, and I hope that we will, sort of join together to lift our country up. It's much needed. Thank you.
Amen.
I want to plug a book, but it's not my book. The last thing I want to say is the last book I would want to plug is a book called Freedom National, The Destruction of Slavery in the United States from 1861 to 1865 by a historian named James Oakes. It is a story of the Republican Party, what it did, and how much more effective it was at doing what it did than it's given credit for, particularly by the Dunning School, as well as others. So I highly recommend that book along with the others I've talked about.
Thank you to all the panelists and the audience. I know we could go on this topic for on and on, but we have a time limit. So thank you again. I also want to repeat the CLE password. It is CIP87. I think it might be on the screen. And the next event in the convention is an address by Secretary of Labor Eugene Scalia, and that will begin at 2:45 p.m. East Coast time. Great. Thanks again to the panelists.
Thank you, Judge Lee.
Bye, everybody. Bye, Randy. Bye, Nadine.
Bye, Randy.